Welcome to Fortifying Futures, the podcast that unlocks the secrets of securing your legacy. Each episode is meticulously crafted to demystify the complex realm of estate planning, asset protection, and how your investments are protected. With the expertise of industry veterans and the personal stories of those who have navigated these waters successfully, Fortifying Futures offers more than just information. It provides a blueprint for action. Tune in to Fortifying Futures and transform your legal and financial journey into a strategic masterpiece. Okay, welcome back. We're at episode 4 of Fortifying Your Futures. And I was going to continue our conversation with Eric. I know, Eric, last time we talked about minerals that were in your family, but we briefly touched on probate, and I wanted to unpack that a little bit more about your experience with probate and both the good and the bad with that. So remind me again what was going on for your family situation.
Yeah, so for us, my grandfather did have the minerals that we talked about. They were in his name, and he had passed away, and I didn't really, it didn't come to us as the grandkids, meaning we weren't responsible for taking care of his estate. It was my dad and I guess my aunt as well. And but then when my father passed a few years later, when we went to figure all that out with you, we realized that my grandfather's was never probated. So we ended up having to probate both estates, which seemed to add some layers of complication to things, for sure.
Right. It certainly can, but that's not uncommon. When somebody has assets, whether it's real property, and by the way, real property is just fancy lawyer speak for real estate or dirt, right, as we call that in Oklahoma, right? And so if it's real property or minerals that are held in somebody's name, they don't have clear title to it. So in order for you to get clear title for your minerals, right, we had to probate your father's estate. But before that, we had to probate your grandfather's estate and pass that all the way down. And if I recall, everything went fairly smoothly with those processes, and everyone, the math was fairly simple and was passed down, right?
It really did, yeah, thankfully.
Yeah.
I hear things can get pretty rough
in
that process.
That it doesn't always happen, and I've had some clients that have come to me from the start, and you never know what's going to happen with these families. But it came from the start, and all of a sudden, people got really upset during the probate process, right?
Really? What kind of things were they about? Like who got what, or
kind of? I mean,
brooch, or who got the?
Great question.
Yeah.
The probate process should be relatively simple, right? Take everything this person had and divide it up by their heirs and give it to them. However, sometimes greed kicks in, right? The 3 most important words in every estate is greed, greed, and greed. And so people's personalities really come to the fray, and they really come up to the front, in the forefront of the conversations. And so during the probate process, people got cross. Man, they wanted the family truck, or they wanted the tractor, or they wanted grandpa's shotgun, or they wanted something that was really important to them, but the process didn't allow for that. And so when someone doesn't take intentional steps to change their estate plan, and they leave it up to the state of Oklahoma to distribute their assets, right? But they don't do a will or don't do a trust, and people can get pretty upset because maybe, and I don't think it's happened in your case, but I had a client once where they said 2 people swore up and down that granddad said they could have the house. And I believe both of them. They both said, hey, I get the house. However, there was nothing written down. And so they fought, and they fought. And do you know who wins when attorneys get involved?
Who's that?
The attorneys.
Yeah,
because we get to pay,
That's right.
charge a lot of money to fix those fights.
Mm-hmm.
And sometimes people don't ever see them coming or anticipate they're going to be there. So again, people start to fight over things, and the probate process works really well in Oklahoma. It takes all of the stuff and divides it up by the heirs. That's pretty easy with dollars, right? I can cut a check for 33 cents and $33. It's pretty easy. It does not work well for a couch. It does not work well for a tractor. It does not work well for real estate, and it does not work well when it comes to minerals, right? The only thing it really works well for is for minerals or cash or things like that. Those things are fairly easy to divide numerically, but outside of that, it's really hard for me to get a chainsaw out and cut a couch 3 separate ways. So when this particular client passed away, there was a lot of animosity and a lot of hurt feelings, and so everybody had their vision or expectation of how the assets should be divided in the probate, and that's when it got really ugly. But your particular case is not uncommon. We had to probate both estates in order to get free title, or free and clear title, for you and your siblings to have for the mineral rights. And so it was a really elegant solution to have that done. I'm losing it here. Hang on, I'm going to back up a little bit. So I remember in your particular case, we got the probates wrapped up for both your grandfather and your father, and so now minerals have been distributed to you guys. But that process can be cumbersome. It does take a long time. The courts do take a while. And the other bad thing about a probate, and it didn't happen in your family's case, is that there's a time period where creditors get to show up and argue that they have debts that the estate owes them. And so the probate process, not only does it take a long time and cost a lot of money, but it also invites people to challenge it, whether they have a dog in the fight or not, and that just slows it down. I really like the direction your family is going by thinking of a trust and taking that process out of the court system into a vehicle where you're totally in control. It avoids the extra attorney's fees, it avoids the long drawn out fights, and it avoids third parties showing up throwing a wrench in it.
Can you explain to me again, just how does it avoid probate? I don't understand how a trust just lets me skip that whole process.
Right. Again, another great question. When your grandfather passed away, nobody had authority to transfer those assets to the next generation because he was the owner. He was the only one with authority to transfer those mineral rights, or I think the family farm, or I think the tractor in your case as well. So he was the only one that could do that. And since he wasn't here, the courts had to step in via the probate process and transfer that. So we have to get notice to everybody. Everybody gets a chance to show up who might have an interest in it and the estate, who cares about it, or even strangers off the street can show up to these public hearings. And so when we did that process, we determined that it all should be passed down to your grandfather's heirs, and one of those being your father. And so the court had to issue a final ruling distributing his percentage to your grandfather, or from your father to your grandfather. And when that was all wrapped up, your father then had the title because of the court order, the probate order, giving your father title to all those minerals. So that was step one. And then step two, we had to do it all again because your father owned those minerals and he didn't transfer them. He had them in his name, and so he didn't have authority. No one had authority to transfer those minerals. And when he passed, we had to go to the probate process. A trust short circuits all of that. A trust, we talked about earlier about a trust being a box. And on the side of the box, there are a lot of instructions, but one of the things that's most important in the trust is naming trustees and successor trustees. That's another fancy word for being the legal owner of the assets inside there. And so, let's pick on myself. When I pass away and I name my brother as successor trustee, then my second brother as the second successor trustee, there's always an owner selected for those assets. There's always somebody that's going to be a legal owner of that. And because there's an owner, they have authority to transfer the assets inside the trust. Thus, we don't have to go to probate.
That makes sense.
Yeah,
that's great.
Right. But a lot of times people will draft a trust. There's a lot of places in town that will do trusts, and they're really, really cheap because there's not much in them, and there's certainly no assets transferred into those trusts, right? So if you pass away and you still own those mineral rights in your name, again, we have the same problem. You're not here to transfer those assets to your kids, and we have to probate it.
So even if I've had a trust drafted and signed, we notarize it, we get it, but we don't change the name of, the accounts, the minerals, the whatever, they're still in my name. I pass away, it still has to be probated.
Exactly,
Okay.
100%.
Okay. That makes
Anything
sense.
that's left in your name when you pass away, because you're not here to transfer it, there's no legal owner anymore, now we've got to probate it. And so we have seen a lot of people come to us, very distraught family members, saying, but Dad had a trust. I will tell them, yes, Dad spent a lot of money on this trust, or spent some money, or didn't, only spent a very cheap amount of money. but didn't do the next step of funding the trust. So now we still have to go to probate. And that's maybe the worst of both worlds. They paid for the trust, and then they still have to probate. So we want to avoid that as best we can. And so you'll see a lot of experienced law firms not only drafting the trust and taking the time to ensure they understand their clients' needs and objectives, but then they take the time to actually transfer title to those assets. And that's a big fancy word for, I'm changing the name from, Bob and Sally checking account to the Bob and Sally revocable trust checking account. That's it. That's all funding is. And we transfer like maybe the marital residence, the primary residence, from the Bob and Sally house, right, to the Bob and Sally revocable trust. Now own that. And that's all it is. That's all funding is. But it's so critical.
Yeah, I remember the team at Baltimore Slow really helped us with that because, we had the document, and then I remember them walking us through, okay, we'll make this call for you, we'll help fill out this paperwork, and to make sure we were doing those things correctly.
That's right. What we want to do at Baltimore Slow is we want to make sure that all your assets are in that box. So when people give us statements, we do our best to reach out. We're talking to financial advisors, we're talking to insurance agents, we're talking to 401k providers, making sure all those beneficiary designations are correct. We're making sure all the titling is correct on that. And so we work with clients for several months after the documents are signed to make sure they're adequately funded. And then on top of that, what we really, the secret sauce here is teaching our clients how to use the trust. So when they leave, they're comfortable with what it means and how it works. So as their life evolves, they know how to use the trust. Because if you don't know how to use a tool, what are you going to do? You're going to set it down and not touch it. It's too intimidating, right? I'm not going to mess with it. And then it's a worthless tool. So we're going to teach our clients how to use it, how to become informed, how to become empowered, how to take care of their estate.
That's awesome.
Yeah. So I appreciate it. I really do think the way your family handled the probate process was nice. I really wish all of them ended that way, where people were kind and polite to each other. But I just have too many war stories to the point where I am jumping up and down to all of my relatives, telling them, do not do anything but a trust. You must do a trust. Stay away from probate at all costs. So,
Well, can I ask one more question about probate
Sure.
real quick? One of the things we found was when my brother and I first went and tried to start the probate process, we heard about probate, knew we needed to do it. The court is the actual ones who recommended we find an attorney to handle probate for us, that it required a different level than just us going to the court and doing that ourselves. Why was that the case? What was...
Right.
Yeah.
Well, the probate process is tricky. And in Oklahoma, other states have a different probate process in Oklahoma. So you really want someone that's done this before, that has experience, that has been down this road a time or two, or several hundred times, several thousand times, like Baltimore Slow has, because it really helps you to navigate it and understand how to take possession and how to move that forward. An individual struggling to do it on their own frequently does not dot the I's and cross the T's. We had one probate that came to us after the fact, and they'd done it all by themselves, and they did it with the help of a family friend who was a different type of attorney. And when the judge's order came out, it didn't have the right date on it. So when they went to sell the house, the title company said, we cannot close because you don't have valid title. It was just a date. They were missing a date. So what they have to do, they had to back all the way up and restart that process, giving notice, letting everybody know about it so we could show up and ultimately get the clear title. And we did. We went in and fixed it for them and helped them. But they really would have saved a lot of time and trouble. And I think in that particular case, if I remember correctly, I think they lost that original buyer and they had to settle for a lower price. So we don't want to do that. Right, so we want to go as fast as we can, following the law, to be as efficient as we can to make sure we have clear titles to those assets. Yeah.
Great, thank you.
You're welcome. I also want to point out the probate process is one of those things that in the middle of it, I have a lot of clients come to me after the probate process and say, I don't want to do that again. I don't want my kids going through that. So we find a lot of people come to us afterwards who have done that saying, I don't want to do that. I want to avoid it. And whether you have a will or don't have a will, that's still a probate process for either way. So the only way to avoid probate process is to make sure your assets are titled either in the trust or via some other form to make sure you're avoiding it. So I think your father had a will, which made it nice. Your grandfather didn't. Either way, will or no will, you still have to go through a probate.
That's right. Yeah.
Okay.
Definitely don't want my kids to experience that.
No,
That was-
at
yeah,
all.
No.
Okay. Well, again, thanks for coming by. I appreciate it. Thanks,
Brian.
Eric. Thank you for listening to Fortifying Futures. This is the podcast that unlocks all the secrets and all the mysteries surrounding estate planning. And we want to make sure that we're answering all your questions. So keep them coming. Let us know what's on your mind. Let us know what concerns you may have or anything that we didn't get to. We'll do our best to get to those on the next podcast. And you can reach out to us via email at clientintake@bml.law. Again, that email address is clientintake@bml.law. And you can always call us at 405-701-5355. Again, that's 405-701-5355. And check out our website at bml.law. There's a lot of great information out there, a lot of great resources and tools. And our goal at Balmore Slow is to provide thoughtful law for today and in the future. Thank you.